Hi, Michelle.
Hi, how are you?
Good. I'm going to say goodbye to you just for a minute, and I'll be introducing you back in a sec.
Okay.
Okay, sorry about that. Hi, this is Deirdre Virvo. Thanks so much for joining us today on Let's Talk Seniors Memory Care Issues, Alzheimer's, Parkinson's, and Dementia. Monday through Thursday, 5 p.m. Eastern Standard Time. Join us here live, and we'll be bringing you exciting issues that have to do and topics and talks for seniors. So please feel free to chime in. This is live. Ask your questions. So many people just always write like, fantastic, great show, but ask a question. We're going to have a fantastic expert today, Michelle Lee Beltrano. She is an attorney who does estate planning. She's going to talk about the ABCs of estate planning. Basically, your basic needs. It could be a pretty complicated subject, and a lot of people may need a lot more than what we're going to be discussing today. That's all well and good, but there are some things that everybody needs, no matter what. Before we get started with Michelle, I just want to tell you that I'm super excited that the Dogwood Home, just like Home's Dogwood Home, our boutique senior assisted living for memory care people in Shelton, is opening next week. So I would love to give you a tour or talk to you about it. We're very excited. So stay tuned at the end and you'll see a little clip about it. Before she comes on, I'm just going to tell you a little bit about Michelle. Michelle Beltrano is the principal and owner of Beltrano Law. She's owned her own practice for almost 10 years. It's a boutique firm in Greenwich. She focuses on estate planning. She does trust and estate administration, elder law, and probate matters. She provides concierge services so that all individuals can have access to estate planning services, no matter where they're living. And she's been practicing safe estate planning right now in her office with a mask on, or she'll do it via telephone or FaceTime with you. So feel free to call her. She holds degrees in both nursing and in law, which enables her to bring that combined experience and understanding to her clients. She speaks frequently in the community, is also on the board at Home in Greenwich, an organization that offers programs and services which allow older adults to remain independent and stay in their own home. That is fantastic. She also has 2 children, 10 and 11, who have been homeschooling safely in Greenwich. And we are going to bring on Miss Michelle Beltrano. Welcome, Michelle. Thank you so much for joining us.
Hi, Deidre. Thank you so much for having me today.
Yeah, so you're a nurse and a lawyer.
Yes, I'm still licensed as a nurse, and I practiced clinically for probably about 18 years before I became an attorney. So
Michelle, you look about 30 years old, but okay. So how did that happen? How did you went to nursing school, worked as a nurse for 18 years, which is a big career, went back to school to become a lawyer?
Yes, I just thought, you know what, I need something else to make my life interesting. And certainly now I'm excited because I can actually kind of combine the knowledge of my previous career with this career. And I feel like it really allows me to connect well with my clients too.
Wow, that's fantastic. So did you pick elder care law and estate planning because you love seniors, or how did that come up?
No, I think that, I knew a lot about the challenges that individuals and families face when they were trying to care for their loved one, manage all of that, manage their own home, figure out where they were going to live and how they were going to get the care that they needed. And I think that, having some insight to that, I wanted to help, educate people on some ways to make it a little bit easier, a little bit more manageable sometimes.
And tell me a little bit about At Home in Greenwich.
Well, At Home in Greenwich is one of the most amazing nonprofit organizations that I know of here in Greenwich. Mm-hmm. And they basically it's a social club, a social network of people, but it's also a safety net. So if you could take advantage of all of their fun trips and their fun clubs and all their meetings and their educational pieces, but you can also take advantage if you do need assistance. Their team will help you kind of navigate what you need and help you find what you need, and kind of recommend.
A senior center with advisors?
Kind of, yes, yes. It's it's a club that you join, and then as you need assistance, you can get the resources and assistance to hire those types of people you may need to hire. They even help you find someone trustworthy if you need to replace your roof or get new windows and things like that. So it's not just senior care, but it's really just trying to help you adapt your environment as needed to help you continue to live at home independently, whatever that may be.
That's fantastic. I used to volunteer at a place called Stanford Senior Centers, not the Senior Center at Stanford, but Stanford Senior Centers. I guess you're familiar with it. And they provided unbelievable services for people. If you could come in and they would write your checks and help you do whatever you needed. They would drive you to the doctor. They would do whatever you needed. I helped them hook up people that were at home, homebound, that needed somebody at a food shop for them. But it was amazing, their services. Basically, they were just there for seniors.
And was it all volunteer based as well, or were there
paid on? It's called Senior Center. It's of Stanford, and no, they have social workers and executives. Very few volunteers. They have a small board of people, but social workers basically working there and just helping them in every way. Maybe you want to hook up with them. They're great, and they're funded by an endowment. So
wow, that's great.
They didn't have any rule. They didn't have rules. They didn't have like an overseer. They could do whatever. So they really, like you're talking about, help the seniors with everyone. I loved it, with all their needs, whatever they needed. So if
that's
amazing. We could help them with the roof, or if they need their bills paid, if they need somebody to call places for them, if they need somebody to call the cable vision for them, things that seniors just might need a hand with.
Yeah, it's amazing, what can come up, everything from, getting your printer hooked up to your computer, or
I still need that help. What do you mean?
That kind of stuff, or making sure that you can do FaceTime with your grandchildren or whatever, it's, making sure you figure all that out. It's fun. It's great to help them with whatever it might be.
Yes. Listen, I have a lot of kids, so I spread out my technology questions so they don't think I'm totally inept. I choose each one and ask one little thing to each one. So so I understand totally. Yes. So now tell us a little bit about, I'm fascinated by your whole ABCs of estate planning. You said there is a number of things that people should have no matter what, whether they have a small estate, a large estate, lots of people to leave money to, no money to leave. What do we all need? The basics of what do we need?
Well, I always say that we should have three main documents, and that would be our power of attorney document, our advance directive document, and our last will and testament. Now, for some people, depending on your estate, the basic would also be a revocable trust to go along with your will. It's often called a pour-over will into a revocable trust. But I don't want to say a blanket statement that it's the best for everyone. I don't want to say that by doing that, it's going to keep your estate out of probate. Connecticut is a unique state, and the way I treat each client is that each client needs to come to me, tell me their story, and we need to figure out what's best for them.
So tell us what, for laymen, what each document does. So the power of attorney, who would you appoint as your power of attorney, and what is that for?
Well, the power of attorney document is very powerful, number one, but it basically allows you to appoint someone that you trust to step into your shoes and do the things that you are not able to do, whether it's temporarily because you're in the hospital getting some care done, you have pneumonia, or you're on a ventilator or something like that, or whether it's gradual and you just physically have challenges doing all the things that you normally would need to do, and your power of attorney can help you go to the bank, make those transfers, pay your bills. They can negotiate and figure out if there are different types of insurance claims that need to be filed, whether it be long-term care insurance claims, homeowners insurance claims, health insurance claims. If there's claims that aren't being paid correctly, they can navigate that for you on the phone as long as they provide proof that they're the power of attorney.
Is it a special power of attorney? Is it a limit? Because I know I've done limited power of attorneys for real estate transactions, like my partner and I. But how is this different? Is this a blanket power of attorney? I mean, I think that some parents might be concerned if they give their child a power of attorney and they go in the hospital and they're, So what is it? How does it? Is it limited?
Well, that is a very excellent question. And so generally what I say to my clients is that if you trust the individual you're going to appoint as your agent, it's wise to give them a broad scope of powers because we don't know what's going to come up in life. The craziest things can occur, and you want your agent to be able to handle that without any red tape or stress. But that being said, if you do have any reservations or if you prefer to give them a more narrowed scope of authority, you can absolutely do that. And the document allows you to do that. So you can decide if you want them only to be able to sell your property and deal with all the closing documents and that sort of thing. Or do you want them to be able to apply for Medicaid for you? Or do you want them to be able to handle issues with your health insurance claims if they're not being paid? So, these different questions, I try to give my clients examples of what can come up. And at certain points in your life, things can become extremely complicated. And your primary goal sometimes is just to make yourself well and not have to worry about that red tape. So if you can assign someone else the authority to do that, it's great to be able to give them a broad power of that.
So by doing so, Michelle, are you relinquishing your authority, or can you also chime in if needed?
That's an excellent question too. So basically, your power of attorney agent will only act and only be able to act if you ask them to do that, or if you should lose capacity to do that completely. So if today my husband is my power of attorney agent, but he doesn't do anything for me right now because I don't need him to. But if I should end up in the hospital and I'm unable to manage my affairs because I'm literally in the hospital, he could show the authorities or show my bank his power of attorney document, and then they would be obligated to let him manage my affairs for me.
Well, that's such an interesting question, because I always assumed that a husband and wife had a power of attorney automatically over each other. Is that not true?
Right, exactly. It used to be that way years and years ago. And many people think it's still that way. And so it's great when people can be educated. That's why I always believe that the more you know, the more power you have. And, it just doesn't happen that way anymore, unfortunately. So even
is that a state by state thing, Michelle? Is that like is Connecticut state, or is that just a federal thing that?
It's generally all states now. But back in the old days when I was a nurse, certainly, a lot of things that the family or the spouse could do and just say, yep, I'm so-and-so's wife, I'm their husband, and here's my driver's license, and then they would let them do anything at the bank, at the hospital, anywhere.
No.
So it's definitely
you need a power of
different.
So you need a power of attorney for your health care, even if you're married and your spouse can't do it?
Right, exactly. Yeah.
Wow. So like if I went into a coma, my husband couldn't just talk for me without a power of attorney?
Right. He couldn't talk to your healthcare providers and make any decisions for you. And it used to be always that they could, you know what I mean? It used to be always that we would just talk to the person that was there, the next of what we would assume is the next of kin. But now, because there had been so much, I think, litigation, unfortunately, in the past, the laws have been created, and the entities, whether it's a healthcare facility or financial institution or insurance company or any type of business is really protecting themselves with policies that state that they have to have this power of attorney to manage affairs.
That is something I did not know. So what happens if you go into the hospital and you don't have a power of attorney and you're in a coma?
Right. So basically, it's kind of complicated in a hospital per se. I would say that you could not sign your loved one into the hospital. You could not sign the admission paperwork. You could not sign consent for them to have any medical treatment provided and things like that without the power of attorney. And separate from that, if you were in a coma or in a terminal or irreversible condition, you would not be able to make choices as to whether they were going to be put on a ventilator and have, be maintained, with machines and so forth, even if they were in an irreversible coma or terminal type condition where the healthcare professionals determined that your loved one was not going to come back at all to what they were.
It's amazing. So this is such great information because I just assumed that it was next of kin. Is this the same? I didn't hear you mention healthcare proxy. Is this also a healthcare proxy or is that different?
Well, in New York, they call it a healthcare proxy. Here in Connecticut, we call it a healthcare representative. So it's really, really important that you have the two teamed up. It could be two different people, but you definitely want to have someone appointed as your power of attorney agent and someone appointed as your healthcare representative.
So that's different. So, but if you have a power of attorney, they could also do your healthcare, but a healthcare rep can't do your financial stuff. Is that it?
Your power of attorney agent cannot make healthcare decisions as far as determining whether you're going to be, taken off of a ventilator or whether you're going to have that, what type of end of life care you're going to have. It gets kind of complicated in the hospital itself. That's why I always do both, and I say both are a team, and we need to have both types of documents. But for example, I had someone who I was her power of attorney agent for. She had a severe fall, and she had lost some capacity to make her own decisions. So the surgeons spoke to me about her fall and whether or not surgery was needed. And I had to sign her into the hospital, but I was her power of attorney agent. And then I was also her healthcare representative, but that we didn't come to any decisions whether or not she needed to be on a ventilator or any end of life questions because that just didn't come up for her. But I was able to hire a home healthcare agency and sign that contract for her as her power of attorney agent. I was able to, make sure that I did get information from the hospital when she was there to relay to her family. And then I also was able to get her medical records as her power of attorney agent. So there's a couple nuances there.
So living on the border of New York, and you mentioned the rules are a little different in New York and Connecticut. If you're living in Connecticut and getting a lot of your health care done in New York, do you need the New York paperwork?
You do not need.
Good enough. Like if you're a resident, is that where are you getting the paper from?
Well, generally, I say wherever you live, primarily, get your power of attorney for that area for sure. Get the most updated one you can. But we have many, many clients that live in different states at the same time, or that are planning on moving to other states. So we often recommend that if you're going to be permanently in another state, or if you have business in another state, or many financial accounts in another state, that you also get a power of attorney for that particular state.
So if you're like a snowbird living between Connecticut, New York, and Florida, let's say, you want to get whatever's germane to Florida as well as wherever you're living here.
Right. Okay. Now, the general rule is, though, and this is very important, if you only executed a POA in Connecticut and then you were in New York for a play and then you fell and you ended up in a hospital in New York, they will have to honor your Connecticut healthcare advance directives as long as it was executed correctly on the date that it was executed. So if you didn't have witnesses, or if it wasn't executed correctly, then they could question it. But generally other states will honor your documents as well.
Can you become somebody's POA or healthcare representative after the fact? Like you go in the hospital, you didn't have one, and then can get appointed?
Mm-hmm. Yeah, it really depends. To appoint someone as your healthcare representative, you don't have to have full capacity as you would to execute a deed for example, or something like that. So as long as you know your name and your address and where you are and what you want the other person to do and who that other person is, if it's your daughter or whomever, that's really all you need to know, and you can execute one. We've done many signings and executions in the hospital for sure of these different documents, and it is not the ideal, of course, but it can always be done. Mm-hmm.
Great. So what was the second thing you said? An advance directive?
Yeah, so within the advance directive, there's a few different points in there. One is that you appoint your healthcare representative. You can, if you choose, to list a living will of what what type of medical choices you would like to make if you are in a terminal or irreversible condition or a coma. And you can talk about whether you would want to be on a ventilator or whether you would want to have full code, like a full CPR and full things like that, and whether you would want artificial nutrition and hydration and so forth if you were in that type of a condition.
So a living will is different than a will, because a living will is your wishes when you're alive.
Exactly.
Like to keep you alive, like a do not resuscitate or no extraordinary measures or something.
Yes,
it's different than a will. So do you need a living will and a will?
It's end of life choices. Only if you are in a terminal condition in Connecticut do they kind of, you can specify that. So for each document, I could literally explain for like an hour the details and what you need to know about each document. So there's a
living will and a will. A living will, that means like you're alive and something could be happening to you. And then a will for after you're dead. Like, do you need two different wills?
Right. And you have to be very, very careful when you're saying that. So what you want to say is that you need a last will and testament and a living will. So, but you're right. Living will is, just like you said, it's while you're alive, and it helps give people your wishes. And that's really, the goal is so that you remain in control of your life, whether it be of your financial affairs and your other affairs or your medical affairs and your medical care. It's so that you can really dictate how your life is, continues, and that you're achieving your quality of life that you had originally wanted for yourself.
Now, and the last will and testament, is that just where you want all your money to go? What you want to happen to your kids if they're young?
It's not just that. It's also kind of how you want them to receive your assets. So it's not only who you want to receive your assets, but how. So do you want them to receive, $3 million when they're 21 years old, just outright? Or do you want to kind of manage that a little bit and say, okay, I'm going to give you a portion of it when you're 21, but the trustee can give you any amount you need throughout your lifetime, and pay for anything you should need, whether it's graduate school, a new house, travel to Europe, whatever it might be. So there's different ways that you, again, can remain in control of your own money and your own assets and determine how and when they're used and distributed. So you can do different things with houses, cars, boats, money, and you can determine, you can control more so how it's used and how it's distributed and for how long by the other beneficiaries of your estate. So it's kind of interesting.
Is there a law as to what you have to give your spouse in Connecticut?
Well, there is a law that everything would go to your spouse if you did not have any children. But if you have children at all that are still living, you would not get everything if you did not have a will. So it's very important that, some people have second marriages, and some people have stepchildren, and some people have biological children and stepchildren. So it's really important that you talk to a professional that can really navigate through that to you and with you and kind of explain how things will be distributed when you die. And that brings me to the third most important thing about your whole estate plan is really making sure that you have a thorough plan looking at, number one, do you have any beneficiaries of anything in any of your assets, whether it's life insurance, annuity, bank account, brokerage account, things like that. How are your beneficiaries listed right now today when you're doing your plan? Not how they were listed 20 years ago when you established that life insurance policy. Let's double check. Let's make sure, what you have listed on your accounts, does that coincide with and synchronize with the rest of your estate plan now?
Also, isn't it true that your will is not invited to be divorced?
I don't know that. I don't know if it is for sure. I know that I don't think your whole will is, but that provision may be to your husband or your spouse. I don't know. I know that I always, get a lot of clients who are divorced, and we do new documents. That's one of the turning points in life that I always say, if you have a change in your marriage, if you have additional children, if you move, or if you acquire more property, if you buy a condo in Florida or anything like that, you want to just double check, is your plan exactly how you want it? And that, it might not be every 5 years, it might be every 2 years, but it's always good to stay in touch with your estate planning attorney that you choose so that you can have that relationship and update it or just tweak it a little bit as needed.
So, Michelle, that's a great point. If somebody buys a house in Florida or does something, do they have to come back to you and revise their plan, or does the plan include like any things you buy?
Mm-hmm. It really depends. It may be beneficial for you to add that new property and title it in the name of your revocable trust. If you title property in your revocable trust while you're living, when you pass away, it will reduce the amount of time for your estate administration and reduce the cost by thousands of dollars. So sometimes...
So if you put your actual assets in a revocable trust, you're going to reduce your probate issues, basically?
You reduce the probate time and money. By reducing the time, you reduce the money, the cost that it takes. And also, it allows you to have your trustee and executor can have seamless control of your assets, and it allows your beneficiaries to be able to continue to receive benefits from your estate more quickly.
Now, should your, I love how you put everything so simply, by the way.
Oh, thanks.
I'm taking copious notes.
Yeah, because believe me, I could talk for hours on each point, so that's the problem. But I'm trying not to get in the weeds.
No, but I think like your nurse, lawyer, teacher, because you're very clear. Trustee and executor, tell us about that. Should that be two separate people?
It can be, but it doesn't have to be. A lot of people pick two different people. I always say we generally have a pretty long conversation about that decision. So we want to determine, what's best for you. The executor has certain roles. If everything is mostly titled in the name of your trust, you're already going to have your backup trustee listed. Quite often it is the executor, but they both have a little bit different roles. And I always say try to have someone who's geographically available, ideally, especially if it is a trustee, because they are going to be possibly acting on your behalf when you're alive and when you pass away. And so that is important.
Is this typically a spouse or a child, or do you not recommend spouses if you're the same age? Do you recommend your children then?
Mm-hmm. Most people that are well and don't have any chronic conditions do appoint their spouse as their backup trustee. You are allowed to be your own trustee while you're living and while you're able to manage your own affairs. So we would only list a trustee, and generally it's your spouse, and then it's your children or some other trusted brother or sister or other person that you would trust to manage it. Certainly a lot of my clients do not have any children, so we try to figure that out and figure out the best person to do that for you. And, you know, then for the executor, the role is a little bit more, we hope with the right plan, that the role is a little more condensed, that they won't have to spend as much time on it. They certainly cannot act on your behalf until you pass away. So they're not doing anything until the estate administration process actually gets started.
So what does an executor actually do if you pass away?
They sign a lot of papers. They can either try to do it themselves, or they can hire an estate administration attorney, and they have to file the paperwork with the probate courts in Connecticut in the town where the person died. They have to file an estate tax return, even if they don't owe any taxes.
Right. Final return.
And
so there should be somebody kind of local to your state?
It could be. Many clients do not have anyone local, unfortunately. So, you know, we do figure it out, even if they are from Massachusetts or from California. We do work with executors from all over. So.
And do the people have to agree? Like if you assign your children and they don't want to be it, do you have to get their agreement?
Well, you know, they are allowed to resign at any time. So generally we put that in the document, in the will. So if you appoint, let's say my mom appointed me as her executor in Georgia, and unfortunately I'm very ill and my child is very ill or something like that. If I was unable to be an executor for someone, even though I was appointed, I could send a formal writing saying that I'm resigning as executor, and then hopefully they have another backup person listed.
You know, it's funny, my parents had me as the executor for their estate for, I don't know, 30 years. And then about 10 years ago, they called me and said, oh, you know, we changed it. You were putting your brother as the executor, my younger brother. And I said, oh, like, why? And they said, well, you're really busy and he's not. And I'm like, Michelle, for a minute, I was insulted. Then I was like, oh my God, what a relief. Like, that's a huge job.
Yes, it is.
Job. I haven't gone through it, thank God. My mom's still alive. But I've had friends that this is like can be very encompassing.
Oh, yes.
So I was like happy. Well, now we're co-executors. But I was like, ugh, that doesn't look like a fun job. So it seems more entailed than you're saying.
Well, you know, and you're right, actually, because so let's say, you know, both of your parents were gone and there was a property to sell and to go through. So the executor, if they have to go through all the property from the last 50 years that was in that house, they come to me and they're pulling out their hair. So it can be very, very onerous, and it just depends. It depends how much pre-planning is done and what's kind of in the works. But you're right. It can range. It can absolutely range from something very easy to something very complicated. We have a lot of clients that own an interest in a business, and they own like 3 pieces of real property, and they have, you know, a car collection, and they have different stocks and things. So the more complicated the person's life is that passes away, or the more complex their assets are, you know, certainly that executor is going to potentially have more work. But if the client titles all of those assets, including all the houses, the car, the stocks, everything in the trust before they pass away, it will simplify things greatly and reduce the time it takes for the executor to do all.
If you have a business, should you name somebody that could take it over, close it down, or buy it, or do something with it before? Is this part of a will?
I'm certain that you can do that if there was somebody that you wanted to have it go to, or have them buy it, I guess. Generally, you don't direct someone to buy something when you die, but you could definitely list, who potential people that would have an interest in your business. And if typically a lot of individuals have some sort of chronic condition, and they know that they're winding down and they need to wind down their business at the same time. At that time, while the person is still alive, even if they have a chronic condition, a lot of times they're able to discuss what they want to do with the business while they're alive. And that's really the key, is to try to do as much planning as you can ahead of time, because if you wait, it can be extremely costly, especially with businesses.
My girlfriend, my girlfriend in New York, her father had his own accounting practice and had to go to a nursing home. And she had to figure out what to do with his clients, the taxes, the years he had of taxes. Like, it was it was like big, because it was a tax business. So she had to figure out, did she have to give people like 7 years of tax returns? Where were they? Like, what did she have to do? He was in the middle of, it was like,
wow.
It was a lot of work. And then
yes.
He was cognitive enough and didn't want his house sold, but she had to sell his house for his care. So it became like a big to-do for a number of years. He's still alive. But this has been going on for like 8 years. So,
one thing, and this is a great thing as far as estate planning for business owners, what you can do is you can speak to an attorney who specializes in succession planning. And I know a wonderful attorney, Doug Singer. He specializes in that, and he's outstanding. So, it is, certainly the more complex your business is, absolutely, you should have your own separate plan just for your business. And that is not something that I specialize in. But certainly we coordinate efforts with your accountant and your other business owners and the business experts and so forth.
So Michelle, great point. Do you talk to our accountants during this process? So if you do our estate plan, are you also getting in touch with our accountant to figure out what's happening, or how does that work?
Yes, it's very, very important that your estate planning attorney should always coordinate efforts with your accountant for a variety of reasons. Not every day, obviously, but when you're executing a certain type of trust or any trust, you want to make sure that your accountant has that information. If you are doing anything with transferring the title of any assets, you certainly want to make sure your accountant knows that as well. And often, we obtain tax advice first before we make any final decisions on the estate plan, because quite a lot of what you do in your estate can have different types of tax implications. So whether it's capital gains implications, or whether it's income tax, or whether it's conveyance tax implications, as you know, with real estate, there's all types of things that we have to consider.
And the difference between a revocable and irrevocable trust?
Again,
I know that's a big question. I know that's
I'll make it very simple.
Answer.
I'll make it simple.
Okay.
There's so much to say about each one, but for an irrevocable trust, let's say I'm the grantor, I'm going to establish an irrevocable trust. Once I do that, whatever asset I title into the irrevocable trust, I no longer have any control over. So you relinquish control, and you don't have any benefit of that asset during your lifetime. And you cannot be your own trustee. For the revocable trust, you You can remain in control during your lifetime. You can put things into the irrevocable trust, take things out. You can benefit from it your whole lifetime. And you can be your own trustee and your own beneficiary. So,
but the irrevocable has the 5-year look back. So is that the benefit of it? So why would somebody do an irrevocable?
There's a lot of different types of trusts. So just think of there being 40 different types of trusts. So we could never say for every irrevocable trust that there's always a 5-year look back period. But for a lot of individuals, if they are titling an asset into the irrevocable trust for purposes of preserving assets, then the clock does start ticking. If they should ever need to apply for long-term care benefits with the state of Connecticut, then there is a 5-year look-back period to the point that it was actually titled in the name of the irrevocable trust.
But that's not the same for irrevocable trust, right?
Right.
So, like my mom has an irrevocable trust and has for 25 years with her house in it.
An irrevocable?
Yes.
Mm-hmm.
Which means you can't reverse it, right?
Well, that's a whole nother conversation too.
Okay.
But
everything is complicated.
It just means that she can't go in and say herself. She cannot go in and say, "I want my house back in my name." Once she puts the house in her name, out of her name into the irrevocable trust, yes, she cannot go back and just put the house back. She cannot put it back in her name.
So if she were to sell her house, that goes into the trust, which my siblings and I are the trustees of. Couldn't we give her that money back to buy a condo or something? What if she wanted to downsize?
Well, she couldn't sell the house. Only the trustees of the irrevocable trust could sell the house. So they have all the power.
So let's say we're the trustees, we sell the house. Couldn't we buy her a smaller house or another house?
You can buy the trust anything you want, and you can let her live in it.
Oh, okay.
Mm-hmm.
So the trust, as long as we're in agreement.
The trust would continue to own whatever it was. Yeah, that would be the ideal situation. And there's so many different nuances to every choice, and every client is so different. So we have to look at all of the different things, all of the pieces of information before we would make a decision about that. A lot of people call me on the phone and they just say, "Oh, I want to do an irrevocable trust. I want to put my house in it. I want to do this and that." And then by the time I educate them, they say, "You know what? Maybe this isn't the best idea." And that's what I always tell them. Let's wait until you hear everything that you need to know before making this decision.
It's a lot to know.
Mm-hmm. It is a lot. We spend quite a lot of time, and some people do think we're like McDonald's, like you come up, you order a trust, and it's ready the next week. It's not really that. It's really, it's really important for you to have the knowledge that comes with all of these tools, because there are a lot of consequences to doing these different choices, and it's important that you know that before signing away at the end.
It's really a lot to know, and you really know a lot, and make it pretty simple, which I love. You really break it down in layman's terms. So like the ABCs of trust planning, everybody should have at least, tell me again, the POA,
the advanced directives, and the last will and testament will, with a revocable trust or without. It depends on but everyone absolutely needs a last will and testament.
And that's fantastic. So those are at least the musts.
At least.
Everybody should have. And you have just helped so many people about the POA that I'm sure they have no idea their spouse is not in charge of them.
Right.
Happy knowing this.
Right. Yeah.
I don't know, but that is eye-opening. So I am definitely going to do something right away about these things, tell you the truth. But Michelle, fantastic. Any last words of wisdom? Will you come on again and tell us a little more of the more complicated stuff?
Yeah, I mean, it would be wonderful to talk with you again. Like I said, there's so much to talk about, and I think it's so important for everybody to, number one, plan while you can. When you lose capacity, you can't do any planning. So that's a whole nother conversation that we can have about capacity and planning. Just don't ever think it's too late to plan. See what you can do. Even if one of your loved ones does have some capacity issues or memory issues or certain diagnoses, just see what you can do.
I am so there with you, because I just met with like my mom, who's 83, and her girlfriend the other day, and she's also 83, and they live in big houses still, and they're kind of too tired. They don't want to move because they're too tired to think about where to go. And I'm like, you really should do this while you're in charge and you're fully there. And I know, physically it's hard to move out of the huge house, but you could have people help you do that. But while you're in control, you decide where you're moving next. So we're not moving you. Why do you want us to make that decision for you? You should be deciding now what you want to do.
Right.
And I guess they did. They didn't want to do anything.
Yeah. Yeah. And most people, they're not alone. They're not alone. I mean, most people just feel like, oh, this is like paying taxes or going to the dentist, and nobody really wants to do it. But when you're done, I guarantee you all of my clients have had a great weight lifted from their shoulders, and they feel so much more peaceful that they have this written down, and their wishes will be followed because they have to be now that they're legally in a document.
Yes, my mother-in-law, we moved her when she was about 82 from a big house to an apartment. Then an apartment in New York to near us in Stamford to congregate living. Then from congregate living, she needed memory care. But because she moved herself basically from the big house to the apartment to the congregate living, she had a lot of choices. Where she wanted to live, what she wanted to take, who she wanted to live near. So I was so grateful that she did that while she could do it. So we weren't just deciding what kid she was going to live near or something. So it's kind of what I'm telling my mom and her friends, like, while you're still making the choices, you go through your stuff. Why do you want us to do that? You go through everything. Yeah, it's way better. So planning. And people are living so long these days.
They are. They really, really are. It's unbelievable.
Yeah, that's why we have to keep working, Michelle, because
I'll be working till I'm like 110.
That's crazy. Well, thank you. You have been wonderful, Michelle. Let me just put your information up again. Michelle Beltrano, 203-340-2610. Safe planning from your home. You could come in or stay at home and plan, right?
Right. Yeah. We are very COVID safe for sure.
Thank you so much. And thank you so much, Michelle. It was lovely to meet you over Facebook Live. And I will be talking to you again.
Thank you so much for having me. I appreciate it.
Thank you. Yes, do come again. Look forward to it.
Okay, great.
Bye now. Thank you so much. Michelle was so informative. She was really eye-opening. Things change all the time. So we really have to be talking to an estate lawyer about what's going on, because who knows all this stuff? She's amazing. So Michelle Beltrano, please reach out to her. She's crazy amazing. I was taking copious notes. So if you saw me looking down, that's what I was doing. I just love to learn this stuff, and I have a lot to do now. And I'm sure you do too. So until tomorrow, I look forward to seeing you on Let's Talk Seniors.
Hi, Deirdre here again. Thank you for joining me on Let's Talk Seniors Memory Care Issues. Is this an issue hitting home? Do you have a parent or loved one with memory care issues who you feel is not safe at home anymore? Are isolation, falls, and safety issues becoming a big concern? Welcome to Dogwood Senior Home, premier boutique residential senior living specializing in memory care. It's country living at its best in the Huntington section of Shelton, Connecticut. We're truly a home with only 6 senior residents living as one family unit. Senior residential homes are concepts sweeping the nation with 47,000 across the U.S. We're pleased to open Dogwood Senior Home as it will be only number 6 for Connecticut. Brand new, sparkling clean, opening mid-June. And safe, safe, safe. We are COVID-free. Residential care homes boast a very low COVID infection rate across the nation. This is due to the intimacy of size and speed in which the caretakers can shift to accommodate immediate needs. They are much safer than the large homes and facilities, as you can imagine. It has been documented that residents have less falls and a better quality of life in a residential home environment. Our home is more affordable than the big box facility. You pay one all-inclusive price, and that price is guaranteed for the life of the resident. With an incredible 1-to-3 caregiver ratio, which you won't find anywhere else. Our friendly, loving caregivers are dedicated and trained in Alzheimer's, dementia, and Parkinson's issues. We're only taking 6 residents, so the home will fill up fast. Call me at 203-689-7562 for a talk and tour. I would love to meet you and your loved one. See you soon. Bye.